I am Shaira. Let us talk about nature and form of a contract. Article 1458. By the contract of sale, one of the contracting parties obligates himself to transfer the ownership of and to deliver a determinate thing, and the other to pay therefore a price certain in money or its equivalent. A contract of sale may be absolute or conditional. What is a contract of sale? It is a contract whereby one of the parties, the seller, obligates himself to deliver something to the other, who on his part binds himself to pay therefore a sum of money or its equivalent on his price. Here are the characteristics of a contract of sale: consensual, bilateral, onerous, commutative, nominate, and principal. Like every contract, sale has the following elements: consent or meeting of minds. Object or subject matter refers to the determinate thing, which is the object of the contract, and cost or consideration refers to the price certain in money or its equivalent. Natural and accidental elements are the essential elements of a contract of sale, or those without the presence of all of which no sale can validly exist. Natural elements are those which are deemed to exist in certain contracts in the absence of any contrary stipulations that warrant against eviction or warranty against its effect. Accidental elements are those which may be present or absent depending on stipulations of the parties, like conditions, interest, penalty, time or place of placement, and more. Article 1459. The thing must be licit and the vendor must have a right to transfer the ownership thereof at the time it is delivered. Requisites for the object of the contract of sale. Aside from being determinate, the law requires that the subject matter must be licit or lawful, that is, it should not be contrary to law, morals, good customs, public order, or public policy, and it should not be impossible. And all rights which are not intransmissible or personal may also be the object of sale, like the right of usufruct. Licit and illicit things. Article 1459 of the Philippine Civil Code requires that the object of the contract of sale must be licit or lawful. Kinds of illicit things. Things that are illicit or illegal per se are things that are inherently unlawful. An example of this is the selling of rotting food for consumption. Things that are illicit per accident, then, are things that are illegal because of provision that declares it unlawful. An example of this would be the selling of prohibited tickets and illegal drugs. Right of vendor to transfer ownership. One can sell only what he owns. It is essential in order for a sale to be valid that the vendor must be able to transfer ownership, and therefore, he must be the owner or at least must be authorized by the owner of the thing sold. It is a well-known principle of law that nobody can dispose of that which he does not have. Sufficient if right exists at time of delivery. Article 1459, however, does not require that the vendor must have the right to transfer ownership of the property sold at the time of the perfection of the contract. It is sufficient if he has the right to sell the thing at that time when the ownership is to pass. Article 1460. A thing is determinate when it is particularly designated or physically segregated from all others of the same class. The requisite that a thing be determinate is satisfied if at the time the contract is entered into, the thing is capable of being made determinate without the necessity of a new or further agreement between the parties. When a thing is determinate. Example: 3 colored bags delivered by the vendor Susan into the house of the buyer Sarah and were set apart and distinguished from all other bags sold. It is sufficient that the thing is determinable or capable of being made determinate without the necessity of a new or further agreement between the parties to ascertain its identity, quantity, or quality. Example: Article 1461. Things having a potential existence may be the object of the contract of sale. The efficacy of the sale of a mere hope or expectancy is deemed subject to the condition that the thing will come into existence. The sale of a vain hope or expectancy is void. Things having a potential existence may be the object of sale. it is reasonably certain to come into existence as a natural increment or usual incident of something in existence already belonged to the seller, and the title will vest in the buyer the moment the thing comes into existence. Sale of a mere hope or expectancy. The sale refers to an expected thing which is not yet in existence and not to the hope or expectancy which already exists, in view of the condition that the thing will come into existence. But the sale of a vain hope or expectancy is void. Example, sale of sweepstakes or raffle ticket that is yet to be drawn. Article 1462. The goods which form the subject of a contract of sale may be either existing goods owned or possessed by the seller, or goods to be manufactured, raised, or acquired by the seller after the perfection of the contract of sale, and this title called future goods. There may be a contract of sale of goods whose acquisition by the seller depends upon a contingency which may or may not happen. Goods which form the subject of a contract of sale may be either existing goods or goods owned or possessed by the seller, and future goods or goods to be manufactured, raised, or acquired. A sale of future goods, even though the contract is in the form of present sale, is valid only as an executory contract to be fulfilled by the acquisition and delivery of the goods specified. The first paragraph 1462 does not apply if the goods are to be manufactured, especially for the buyer, and not readily saleable to others in the manufacturer's regular course of business. Article 1463. The sole owner of a thing may sell an undivided interest therein. Sale of undivided interest in a thing. Article 1463 covers only the sale by a sole owner of a thing of an undivided share or interest thereof. The sole owner of a thing may sell the entire thing or only a specific portion thereof, or undivided interest therein, and such interest may be designated as an aliquot part of the whole. By co-owner, the co-owner of a thing, being the owner of the undivided interest therein, can dispose of his share even without the consent of the other co-owners. Example, Anna can sell to Ali the entire parcel of land, or only 1,000 square meters of the land, in which case he becomes the sole owner of the remaining 1,000 square meters, and Ali the portion sold, or he may sell the undivided half of the land without specially designating or identifying the portion sold, in which case they become co-owners. As a co-owner, Anna or Ali can convey or transfer the title pertaining to the undivided half of the land, for vital to the validity of a contract of sale is that the vendor may be the owner of the thing sold. Article 1464. Sale of an undivided share of a specific mass. What is fungible goods? It means goods of which any unit is, from its nature or by mercantile usage, treated as equivalent of any other unit, such as grain, oil, wine, gasoline, and more. Effect of sale. The owner of a mass of goods may sell only an undivided share thereof, provided the mass is specific or capable of being made into a unit. By such sale, the buyer becomes a co-owner with the seller of the whole mass in the proportion in which a definite share but bears to the mass. It must follow that the aliquot share of each owner can be determined only by the measurement of the entire mass. If later on it be discovered that the mass of fungible goods contained less than what was sold, the buyer becomes the owner of the whole mass. Furthermore, the seller shall supply whatever is lacking from goods of the same kind and quality, subject to any stipulation to the contrary. Risk of loss. If the buyer becomes a co-owner with the seller or other owners that remain with the mass, it follows that the whole mass is at risk of all the parties interested in it, in proportion to their various holdings. Take note that in the sale of undivided share, either of a thing or that of goods, the subject matter is an incorporeal or intangible right. Here, ownership passes to the buyer by the intention of the parties. Article 1465. Things subject to resolutory condition may be the object of the contract of sale. What is a resolutory condition? It is an uncertain event upon the happening of which the obligation or right subject to it is extinguished. Hence, the right acquired in virtue of the obligation is also extinguished. Example, Zach sold a parcel of land to Beth subject to the condition that Zach can repurchase the property within 3 years from the date of the sale. If Zach exercises the right to repurchase, that a sale made by bank account before the last of the 3-year period falls. Article 1466, in construing a contract containing provisions characteristic of both the contract of sale and of the contract of agency to sell, the essential clauses of the whole instrument shall be considered. By the contract of agency, a person binds himself to render some service or to do something in representation or on behalf of another, with the consent or authority of the latter. Sale may be distinguished from an agency to sell as follows. Here's an example. Article 1467. By the contract for a piece of work, the contractor binds himself to execute a piece of work for the employer in consideration of a certain price or compensation. The contractor may either employ his labor or skill or also furnish the material. For example, if Kim is buying a pair of shoes of a particular style and size from Gem, which the latter manufactures or procures with the general market, but the same is not available, an order for one would be a contract sale. On the other hand, if Kim places an order for a pair of shoes with a particular shape because her feet are deformed, the fact that such kind of shoes is not suitable for sale to others in the ordinary of the seller's business is to be manufactured especially for Kim, and upon her special order, makes the contract one piece of work. Article 1468, the consideration of the contract consists partly in money and partly in another thing. The transaction shall be characterized by the manifest intention of the parties. If such intention does not clearly appear, it shall be considered a barter if the value of the thing given as a part of the consideration exceeds the amount of the money or its equivalent. Otherwise, it is a sale. By the contract of barter or exchange, one of the parties binds himself to give one thing in consideration of the other's promise to give another thing. On the other hand, in a contract of sale, the vendor gives a thing in consideration for a prize in money. For example, Girlie and Boye entered into an agreement whereby Girlie was to deliver oranges worth 10,000 to Boye, who was to give apples also worth 10,000. This is a contract of barter. Assume now that the contract between Girlie and Boye was for Girlie to deliver oranges to Boye, who agreed to give apples or to pay 10,000 cash. If Boye, instead of apples, paid 10,000 cash, it is clear that the resulting contract is that of sale and not barter. Article 1469. No sale if price not certain and ascertainable. And there are cases when price is considered certain. The parties have fixed or agreed upon a definite amount, and if we certain with reference to another thing certain, or the determination of the price is left to the judgment of the specified person or persons. It must be understood that the last two cases are applicable only when no specific amount is stipulated by the parties. As a general rule, the price fixed by the third person specified by the parties is binding upon them. There are, however, exceptions. When the third person acts in bad faith or by mistake, as when the third person fixed the price having in mind not the thing which is the object of the sale, but another analogous or similar thing, in which case the court may fix the price. But mere error in judgment cannot serve as basis for disregarding it. For example, Leah sold Dan a diamond ring. The determination of the price was left to Faye, whom the parties thought was a jeweler. If Faye acted by mistake, as when he is incompetent to know the price of the diamond ring, or in bad faith, as when he is connived with Leah, the court may fix the price. A fact where price not fixed by two persons designated. Article 1470. Gross inadequacy of price does not affect the contract of sale, except as it may indicate a defect in the consent, or that the parties really intended a donation or some other act or contract. As a general rule, while a contract of sale is commutative, mere inadequacy of the price or the fact that the bargain was a lurid one generally does not affect its validity when both parties are in position to form an independent judgment concerning the transaction. This rule holds true in voluntary contracts of sale, otherwise free from invalidating defects even if the price is inadequate or low. The inadequacy of price, however, may indicate a defect in the content such as when fraud, mistake, or undue influence is present, in which case the contract may be annulled not because of the inadequacy of the price but because the consent is vitiated, or where the price is so grossly inadequate or low as to be shocking to the court's conscience that no man in his right mind would accept. As a general rule, a judicial or execution sale is one made by court with respect to the property of a debtor for the satisfaction of his unpaid indebtedness. Like involuntarily sale, mere inadequacy of price is not sufficient ground for the cancellation of the execution sale. If the price is so inadequate as to shock the conscience of the court, a judicial sale, say of real property, will be set aside. Thus, in a case the sale of a land with an assessed value more than 60,000 pesos for only 877.25 was set aside by the court. The validity of the sale is not necessarily affected when the law gives to the owner the right to fee, as when a sale is made at public auction, upon the theory that the lesser the price, the easier it is for the owner to buy back the fee.